Good evening. One of the vital parts of the architecture of our society is what are called the Chapter 9 institutions. These are institutions set up by the Constitution under a heading, State Institutions Supporting Constitutional Democracy. Under that chapter, it calls for the establishment of bodies that help to protect citizens and ensure they get proper treatment and services from the state. You know these institutions. They include the Human Rights Commission, the Public Protector, the Auditor-General, the Commission for Gender Equality and several others. Tonight, we're discussing if they are effective and if they are doing their job. Joining us this evening in our studio is Professor Susan Boyson, a well-known analyst and Professor of Politics. Lawson Naidoo is the Executive Secretary of the Council for the Advancement of the South African Constitution. He's in our Cape Town studios tonight. And Tsiamo Sedumedi is the Managing Director at Mqilisi and Ndlovu and Sedumedi Attorneys. All of you, thank you very much indeed for coming. Good evening.
Thanks for the invite.
Tsiamo, firstly, what are Chapter 9 institutions? I mean, what are they actually supposed to do?
Like you said in your introductory remarks, Stephen, these are basically set up to promote and protect various aspects of the Constitution. They are there to support our constitutional democracy. Obviously, they've got different mandates. Public Protector will be there to ensure there's no maladministration in state affairs. There's an AG that will ensure that there's public accountability for the funds. There's an IEC that ensures that every 4 years we've got free and fair elections. We've got a Commission for Gender Equality that must ensure and monitor the advancement of women's rights in a society. And amongst others as well, the South African Human Rights Commission, I think in the last few months have been quite hectic in Alexander to monitor and ensure that the state advances the human rights as enshrined in our Constitution. So broadly, that's what these Chapter 9 institutions are being set up to do.
It's almost as if the people who wrote the Constitution didn't trust politicians.
But I think they already envisaged that there's a need for checks and balances in our constitutional democracy.
Okay, what powers do they have? And I mean, some of the powers would seem to be quite extensive. The Public Protector can order the President to do something. The Human Rights Commission can do the same. The Auditor-General can tell you whether or not you've got your numbers right.
Correct. I mean, if you look at the recent judgment of the EFF versus the Speaker of Parliament, the Concord, they made very, very clear that the remedial action of the Public Protector are quite instructive. You cannot just willy-nilly ignore the remedial action of the Public Protector. So you're quite correct. They are very, very extensive. I know there's been criticism about the efficacy of the AG, but I think there's been recent amendments to the law to ensure that there's more teeth that's been given to the AG to ensure that its findings are actually given effect. Because I think there's been a concern that its findings are not generally adhered to by various organs of state.
Lawson Naidoo, I mean, the obvious question is how do you make sure that our commissions do what they're supposed to do? And I imagine part of that is it depends on who you appoint to them. You need to make sure that the right people are appointed or people who are not aligned to political groups.
Indeed, and you know, as we know that the people who work in these Chapter 9 institutions are appointed, they're appointed by the President, but after a parliamentary process and a recommendation is made to the President after an open and transparent process in Parliament. However, what is often lacking in that process is an assessment of the skills and attributes that are required to execute the functions of those positions. You know, the one exception is probably the position of the Auditor-General, which has the incumbent has to have very specific technical skills to be able to do the job. But for pretty much most of the others, the requirements for the job are fairly loosely defined. So, you know, it ends up being a political compromise as to who gets put forward to these institutions, and they're not always the best people to give effect to the mandates that the Chapter 9 institutions have. And that is really to buttress and support the human rights culture that our Constitution is premised on, and to ensure that the rights that are in the Bill of Rights in Chapter 2 of the Constitution are in fact implemented and protected.
I mean, the political contestation around this can be quite important, but if you look at the powers and the importance of these bodies, for example, the Electoral Commission runs our elections. I mean, it would seem vitally important to make sure that the right people are on the Electoral Commission.
Indeed, it should be. You know, we need to have the right people of the right quality with the right sets of skills to be able to manage these institutions, to ensure that they are able to execute, as I said, their constitutional mandates appropriately, so that an electoral management body is able to deliver credible, free and fair elections every 5 years, and local government elections in between, that they manage the other processes of registration of political parties. They now have added responsibilities that will come into effect soon, where they will have to publish details of the private financing of political parties. And then you take the three rights institutions, the Human Rights Commission, the CRL Commission, and the Gender Commission, and they have very specific responsibilities in terms of protection and promotion of human rights. And we must go back again. You asked earlier, how effective are these institutions? Well, there was a parliamentary committee 10 years ago that was chaired by the late Professor Kader Asmal, which recommended the rationalization of these three human rights bodies into one human rights and equality body with different aspects of their work. But that's something that Parliament hasn't really engaged with in the 10 years since the report came out.
Professor Boyson, okay, we live in I think for the moment, a cynical country, sometimes very politicized environment. How would you describe the track record of all of these bodies? And I imagine it depends on which one you look at, and we're also looking at over a period of 20 plus years.
There certainly have been serious ups and downs there, but if one has to generalize in one sentence, I think it's been pretty dismal. Variations, yes. Occasions when the IEC has been doing really good work. Other times when the public protector seemed to be ready and capable to stand up against politicians and political dictates of the day and be seen to be forwarding that support of constitutional democracy. But overall, I think the performance has been quite dismal. Just think of Gender Commission. Just think of Human Rights Commission. Suddenly now with Alexandra we see them doing what I think they really should have been doing all along. Why have they not been doing that? We know in the early days of democracy in the late 1990s, the Human Rights Committee were going to look whether the Constitution is actually furthering sufficiently those human rights guaranteed in the Constitution, but they were basically stopped from doing that. Auditor-General has been doing his work, but he hasn't had teeth up to now. The Public Protector is a story on that institution's own. It has been so dependent on who the prime occupants of the positions have been.
All of this, I mean, involves politics, right? Because it involves political leaders. So, for example, the Gender Commission in 2006, during the Zuma rape trial, Zuma's opponents criticized it.
Yes.
Okay.
Yes.
If we go to the Human Rights Commission, is currently doing important work, I think, in Alexandra. But Lebogang Maile, the Human Settlements MEC in Gauteng, had very angry words for it earlier this week. And you would have seen that report here on the Full View. We have the huge political contestation around Public Protector Advocate Busisiwe Mkhwebane now. Is it actually quite difficult to come to an accurate and objective assessment of how well these organizations have done if for some reason or other they get dragged into politics all the time?
Yes. I think, in the first place, I think it is possible to assess whether they've been doing a good job, although the question is whose judgment will be used there. And then a good point that you raised just now, can we actually trust the politicians? Probably in many cases, no. It has been the Constitutional Court, the higher courts and Constitutional Court has been pronouncing on the operations of several of these organizations. We can think back to around 2005, 2006, where former Public Protector Lawrence Mushwana's Oilgate report, where that was thrown out by a higher court. So it seems that the Constitutional Court or higher courts are the associations, politicians, but the ones who really are required at the end of the day to judge whether that can be done. But then we can even look at the Constitutional Court. In a series of judgments, we can think more than a decade ago to the Grootboom case, for example, where they had started introducing that culture of, yes, these rights, basic human rights, should be realized and the state is accountable to the extent that their resources and capacities basically allow that. So even at that very highest level, there isn't always a clear-cut guarantee of human rights.
Tiabo, one of the things that must have developed over the last 10, 15 years is a body of law. In other words, judgment after judgment after judgment about how these commissions are supposed to govern their affairs and what is considered, I love this phrase, rational, but legally rational or not.
Correct. Yes, you're quite correct, which is why I think we need to find a balance. There's a role for the Concord, but there's also a role for these institutions. So I don't think we must just necessarily then say we need to just defer the promotion of the human rights in the Constitution to the Concord. There's a specific purpose for this institution. All you must ensure that as a state, we put all measures to support their efficacy. So even the Constitution specifically say that in 181.3 that it's an obligation of other organs of state to put measures in place to ensure that these institutions are protected and their dignity is preserved. So I don't want us to have a situation where we seem to be discarding this chapter purely because on the basis of who the incumbents are. Yes, you cannot divorce the fact that the incumbents will end up affecting the efficacy or otherwise of this body. But at the end of the day, it is our task to ensure the institutions are protected by appointing people who are capable and delivering in accordance with the mandates of those specific institutions. Otherwise, you'll end up having criticism purely based on the fact that who is the particular incumbent of that particular institution.
As we build up this body of law, so judgment after judgment that basically spells out what needs to happen in certain circumstances, is there a risk that that the people who then manage these commissions find themselves in really a bit of a straitjacket of rules, that they, before they make any kind of decision, they need to go and see what this ruling was made about in Nkandla, a few years ago, or that ruling about Grootboom 10 years ago? Do they find themselves in a position where actually it's a little bit harder to take initiative because they have to be so careful?
Not quite. The golden thread that runs throughout all this body of keys I'm talking about is rationality. So long as you can demonstrate that you exercise your power rationally, impartially, without fear or favor, that should be your guiding principle as an incumbent of any of these institutions. Obviously, depending on the facts, then that's where it becomes tricky to say how then do you apply those principles on each and every case. So everything will end up being context specific.
Lawson, one of the sort of interesting questions about this, if we try and get to the elements of what makes a successful commission, and we can talk about who's appointed all we like, but there seem to be times when certain commissions are more effective than at other times. Have we seen times when these institutions are actually louder, more muscular, more assertive than they have been perhaps in the past? And is this linked to something in some way?
Well, I think that's absolutely true. I think, as has already been said, we've seen an uneven level of performance amongst these Chapter 9 institutions in the last 25 years, possibly with the exception of the Electoral Commission and the Office of the Auditor-General that have been fairly constant and consistent. But I think in relation to the others, it has been very up and down over the years. But I think we can't lose sight of the fact of the role that Parliament plays in this regard. So these are independent institutions supporting constitutional democracy, and they really play a complementary role to that played by Parliament. These are specialist, specific bodies tasked with dealing with specific issues, but ultimately they're accountable to the National Assembly. So, the Human Rights Commission, for example, produces numerous reports that get sent to and tabled in Parliament, but Parliament very rarely engages with those reports. So, the effectiveness of these commissions and Chapter 9 bodies is really dependent on Parliament taking their work seriously, saying, these are the recommendations that have come into the report. How do we now take that forward? How do we hold government departments accountable on the basis of what the Human Rights Commission, for example, has said? So I think it's the failure of Parliament to play their role properly in properly empowering these Chapter 9 institutions. They don't have enforcement powers or enforcement capabilities, and they effectively rely on Parliament to do that. And I think it's been the failure of Parliament to play that role that has contributed to the weakening of Chapter 9 institutions.
So if we have a situation where Parliament recommends who's going to be in charge of these commissions, and then is also, on your version, able to undermine these institutions by not following up on their recommendations. You have a situation where they're basically caught in the middle, aren't they? They're the donut surrounded by Parliament.
Well, indeed, they're often in that position. They also complain of limited resources. We know, the Human Rights Commission in particular. So, Parliament's got to play its role in terms of empowering these bodies to be able to do their work, and then when they do their work, to actually act on what is being done. So we've seen, for example, that the Constitutional Court then had to step in relation to the powers of the Public Protector and say that remedial action is binding unless set aside by a court. We had to have a change to the Auditor-General legislation to give more teeth to the Auditor-General, because he was submitting reports to Parliament that were going to SCOPA and so on. But there was no action being taken against persistent wrongdoing in financial management across the government departments. So, Parliament is not playing its role, and we're now in a piecemeal fashion trying to plug those gaps by giving additional powers and responsibilities to these Chapter 9 institutions without necessarily giving them the additional resources to be able to implement that.
Professor Boyson, and yet, you know, the Human Rights Commission, for example, seemed to be quite quiet for a while. Suddenly it seems to be everywhere, getting itself into all sorts of things. The Public Protector's Office was sort of seen to be quite quiet for a while, suddenly got itself into all sorts of things. Why is that? Why suddenly are we seeing the Human Rights Commission, for example, doing what it's doing?
Yeah, maybe they have seen the pressure coming on and seeing so much circumstantial and direct evidence of the great inequalities, unbearable inequalities in society, and maybe they're waking up a bit, seeing where those big gaps in our democracy and constitutional democracy are, and at last stepping up to be doing more work. The same, I really ask of the Gender Commission, so sporadic in utterances here and there, but virtually nothing in systematic action. Why suddenly it is the strength of the people, it is in them being held to account. But who has to hold them to account? Should there perhaps be a bigger supervisory body? Besides Parliament, we know Parliament is probably not going to do it very well, because Parliament is always going to be measured as to how well Parliament is going to be assessed. So probably much more public accountability, and ways that they should, in a much more tangible way, be held to account on any arising issue, and be preemptive and educational and advocacy based in what they do. But their roles are poorly defined and they are not sufficiently held to account.
Is there also, and I'm going to put a very cynical spin on this just for a moment, so let me just say that at the beginning, that some commissioners can almost spot a political gap. So, and there is a lot to be said for the power of public opinion. If you do what the Human Rights Commission and the Public Protector's Office are doing now, and you have daily hearings into what's happening in Alexandra after protests, and the SABC comes and films it every day, people are going to be very interested in your findings. It gives you a sense of power. The same could be argued for the Commission for the Promotion and Protection of Cultural, Religious and Linguistic Communities and their investigation into religious leaders. I mean, it's obvious that there needs to be an investigation into, you know, people who claim to resurrect people. And yet through that, they're able to make sure their findings are actually enforced because there's so much public attention. It's almost more effective than Parliament is the attention you get.
Yes, indeed. And they should actually articulate very closely with public opinion and go on the issues, not just those issues that are fashionable or topics of the day, but they should do those in-depth analyses and monitor what is happening in terms of human rights and democracy in South Africa. And then the antithesis of this is actually almost what the Public Protector is currently. She is not accountable probably to Parliament generally, but to a faction, and how I believe her behavior is really very factional at this stage. And then, these commissions, we can think of previous public protectors as well, they've always been delivered out to politicians. And as long as those politicians come in there and have a final say, also in their appointment, they're appointed by committees from Parliament, ad hoc committees from Parliament, where the majority party has got a say. So it's almost a miracle if in a more politicized of these commissions, the politicians do not have that very strong overriding rule, and people are delivered out to who appointed them, and it's almost inevitable that at least in some of them there are going to be political affiliations. But then on the other hand, contrary to the Public Protector, we've seen IEC, when Glenn Mashinini was appointed to head the IEC, there was cynicism because he was seen to be close to former President Zuma. But then he has risen above that and proven himself in multi-presidential context. So yes, the politicians and Parliament have got a huge responsibility to help see greater accountability and performance in particular.
Tiamo, we're great fans in South Africa of changing the law to fix a problem, right? People under the age of 18 are drinking, let's change the law. It doesn't necessarily help anything. They will, at some point, I mean, we've seen with the Auditor-General, for example, and there are great questions about the Auditor-General, but in terms of how that is one office that hasn't been politicised at all. But someone is bound to put up their hand and say, let's change the law around these commissions. Would that help at all?
That will never help in actual fact. Because in actual fact, if you look at even the current legal framework that set up these institutions, it's quite perfect. I don't think, minus the AG, where I think there was a query about its efficacy because it didn't have any enforcement mechanism. But generally speaking, the framework is in order. There's no reason why these institutions should first wait for a public pressure before they could execute their mandates. Human Rights Commission, as an example, it has a mandate in terms of its own act and the constitution for them to continuously monitor government to ensure that the Bill of Rights is being advanced. So there's no need for us to change the legal framework. The system is there and it's perfect. Again, it all depends on the incumbents of those specific institutions.
A lawyer saying the law is perfect. I never thought I'd say it. Can I ask about, so one of the things we've seen is, and we see this in politics all the time, that politics, it's called lawfare. In other words, that a political dispute goes to a court, right? In the case of commissions, and I'm not just talking about the public protector, we've seen it in other commissions. Lebogang Maile, again, over the Alexandra Renewal Project, might well go to court, the MEC, on some of what's happening there. But doesn't that mean that the commission ends up losing anyway because only the rich can really go to court? So it's actually much harder to hold powerful politicians to account than anyone else.
You see, that presupposes that the courts will always favor the rich. And I think that would be a wrong premise to move from. Remember, these institutions as well, they are only subject to the constitution and the law. So there's nothing untoward if we review the decisions of any of the Chapter 9 institutions. We need to have confidence in our judicial system that they would not necessarily advance the cause of the politicians. There would have been cases where, in actual fact, the courts will confirm the correctness of whatever decision that has been taken by any of these institutions. So it doesn't necessarily follow that every time when there's an outcry against the decision of an institution, there will necessarily be an overturning of that institution by the court of law. It's just unfortunate in the past few weeks where there's been so much pressure on the PP's office that most of a decision, or at least two of main decisions have been reviewed and set aside by a court of law. But it doesn't necessarily follow that ordinarily what they're doing is incorrect and it will always be overturned by courts of law. I'm
going to ask Professor Susan Boyson this question as well, but Lawson Naidoo, I'm going to put it to you first. The Auditor-General does not seem to have become embroiled in political fights. And yet I think almost all the other commissions have been, or faced intense criticism for action or inaction when it comes to political issues. How's the Auditor-General, I want to use the phrase, stayed above the fray?
Well, I think, the work of the Auditor-General is fact-based. It's not subject to perceptions or interpretations. It's a simple question of whether monies have been properly spent and accounted for, and where they have not been so. The Auditor-General can very clearly and easily point to the financial statements of a government department or a municipality and point out the error that has been committed and what needs to be done to fix it. So the Auditor-General doesn't get involved in the politics of things and putting a political spin on issues. The Auditor-General, Kimi Mokwetu, produces his reports, releases those reports to the public and the media, and they contain a lot of very key information about how government departments are functioning. I think in relation to the other commissions, their work is a lot more subjective and dependent on the attitude of the incumbents in those commissions at particular points in time. So I think that's the fundamental difference that we see here.
Professor Boyson, do you agree? Is it just because it's technical in nature, or is it because it's accountants and not lawyers?
For me, the core point there in Auditor-General is that he has not had teeth to date. He has been reporting until he's blue in the face, respectfully said, and no effect year after year. Those results, occasionally there was a little blip and everybody would get excited, or things are going way better, but that has not been the case. Overall declines year after year after year. But then, now that he has been given teeth, I think he should really be watching out, because he could very well become much, much more unpopular with the politicians now that he can make definitive recommendations and enforceable dictate enforceable action. The politicians are going to feel much more threatened now that he has got teeth. So let's watch this space.
Lawson, very quickly, if you can. I mean, can you think of any way to sort of ring fence? Do we need to try and take Parliament out of this equation? If Parliament doesn't appoint people to the commissions to try and sort of protect them from political influence, I don't know who does.
Well, I don't think so, Stephen. I don't think we can remove Parliament's responsibility in this regard. I mean, I think we've identified that part of the problem lies with Parliament, and we've got to see how we fix Parliament so that Parliament is able to play its role properly. These institutions have to be accountable somewhere. They're independent institutions, yes, but they're also accountable, and Parliament needs to play that proper role to hold them to account, to ensure that they do their jobs properly, to ensure that they have the resources to do their jobs properly, and when they do their work, Parliament needs to follow up and ensure that action is taken. So, for example, coming back to the Auditor-General, over the years, reports have been prepared, published, sent to Parliament, and the politicians fail to take action. So, the problem lies with Parliament. I mean, I think at the end of the day, across so many different issues that we look at, whether it's Chapter 9s or other aspects of our politics, it's Parliament's failings that lie at the heart of a lot of the problems that we face in South Africa today. And I think it needs to be the focus of what we need to do. As I said earlier, the Asmal report has been sitting in Parliament for 10 years, and they've not engaged with it. And I disagree with what was said earlier that the legal framework is okay. I don't think it is. There's a lot that needs to be fixed, and the Asmal report referred to a lot of that in terms of rationalizing processes within the different commissions, in terms of appointment processes, remuneration, and so on. So there's a lot of stuff that Parliament needs to focus on, but has simply failed to do that.
Lawson Naidoo in our Cape Town studio, thank you very much indeed. My thanks also to you, Tsiamo Sedumeri, and Professor Susan Boyce. And that was On the Record. Thank you very much indeed for joining us tonight.